Okay, hi everybody. Thank you so much for waiting. Everyone's made it. There was some train chaos and such. It's here now, which is great. Professor Violetta Marino-Lax is going to kick us off. So straight over to you, Violetta.
Thank you, Maya. So I can see that the recording is on and people are slowly joining in via Zoom. So hello, everyone, both in person and online, and welcome. Thank you for your patience. It's a great pleasure to have you here at our second Practitioners Meet Academics workshop at the Borders Center for the Legal Study of Borders, Migration and Displacement. As Maya said, I'm Violetta Moreno-Lax, professor here at Queen Mary University of London and the University of Barcelona. I'm also the inaugural director of the center, which we founded in 2022. So this is our second academic year of life. We're focusing on the study of bordering, ordering, and othering processes through law. And we aim for the center to become an excellence hub for intellectual collaboration and the evaluation of the role of law in the making and unmaking of borders, as well as their impact on global processes of mobility and displacement. So the idea of the center is to connect scholars within and beyond Queen Mary Law School to harness existing inter- and multidisciplinary research into law, borders, and migration, with a view to shaping future policy and research agendas in response to global challenges in this field. And our Meet the Practitioners series takes the form of a series of roundtable discussions on topical issues of interest to both academic and non-academic audiences, aiming to charter new pathways to public engagement and joint legal and policy impact. And I'm very happy and grateful to our distinguished guests today, Zoe Battleman from ILPA, Mark Symes from Garden Court Chambers, Eric Fripp from the 36 Group, and from Queen Mary, Professor Elspeth Guild and Ellen Aldy. And today's session has been convened and will be chaired by my dear colleague and Borders founding member, Dr. Maya Gruntler, currently a lecturer in law at Royal Holloway University of London. And what we're going to be doing is to discuss a number of issues with these distinguished academics and non-academics speakers working on asylum and immigration law in the UK, and debate the role that academic arguments can have or do already have in their day-to-day work with refugees and migrants in the current context. So the objective is to unpack how and to propose ways in which both academics and practitioners can work more closely together to bring about effective change, especially, as I said, in the current climate. So I'll pass on the floor to Maya for her to moderate the session. After hearing from the speakers, there will be space for Q&A and general debate. So for those joining online, thank you for posting your questions in the chat so that we collect them and can pass them on to the speakers. Thank you very much, everyone, and enjoy the session. Maya, the floor is yours.
Thank you so much, Violetta, and a big thank you, of course, also to the Borders Center, because without your support and also funding, these events wouldn't be possible. So thank you so much for being so supportive and for having this event for a second time, really, because as Violetta said, we kind of kicked off this series with a workshop in June this year. So this is basically the second event of its kind, and we are really looking to continue the conversation which we started in June. If you weren't able to come to the June event, the recording is on Queen Mary YouTube, so you can have a look at it. And the speakers that we had at the event in June were also practitioners and academics, but most of them probably would count themselves very much in one of these two camps, whereas today I think lots of our speakers really dabble in practice, or not just dabble, but actually are engaged in practice, but also in academia. So kind of have, you know, connections to sort of both of these fields and sort of combine these two aspects in their work. And so I think it's going to be extremely interesting to hear what they have to say. And I'm just gonna introduce our speakers in a little more detail to kind of show you how they have these connections to practice and academia. So Zoe Benjamin is a barrister, and she's also the legal director of the Immigration Law Practitioners Association, but she's also an editor for the Journal of Immigration, Asylum and Nationality Law. And then, of course, Professor Elspeth Gild is a professor at Queen Mary, as Violetta said, and has researched and published extensively in the area of EU justice and home affairs. But she's also senior counsel at Kingsley Napley, where she's part of the immigration team and works in the areas of EU free movement of persons, immigration, and borders law and practice. And then Mark Symes is a barrister at Garden Court Chambers, just across the road, and he practices in all areas of immigration, asylum, and human rights law. He's also an upper tribunal judge, if that's correct, yes. And he has also written books. So he has co-authored a book on asylum law and practice, and also one on immigration appeals and remedies. Ellen Aldi, as Violetta said, is a PhD candidate here at Queen Mary, and she researches inaccessibility of law for women in European spaces of bordering. And as part of her empirical research, she has worked on the Greek hotspot island of Samos with the organization I Have Rights, and she continues to support that organization remotely as part of their strategic litigation team. And then Eric is the joint head of public law and human rights of the 36 group, and specializes in cases on refugees, immigration, nationality, statelessness, and human rights. And he has published a monograph on nationality and statelessness in the international law of refugee status. So really, all of our speakers are practitioners, but also do a lot of writing and editing. And I think this is really interesting because we're going to get lots of interesting views on the relationship between practice and academia today. So that's me done talking, and I'm going to hand over to Zoe. And each of the speakers has about 10 minutes, and then there will be time for discussion and also for Q&A. So Zoe, the floor is yours.
Thank you, Maya, and thank you for arranging this workshop, particularly because I did miss the one in the summer, so I'm glad to be able to make it today. I was up in Durham earlier this year in September for the Critical Legal Conference, and I was presenting this paper on Jacques Derrida and the duty of hospitality and how our recent asylum laws have really deteriorated it. And I walked into Oxfam and I picked up this seemingly unread copy of Lord Dyson's Justice, which someone had donated, I think. And in the second lecture of Lord Dyson's book, he has this interesting 3-4-page chapter called Academics and Judges. And what he says is that we have a symbiotic coexistence. If you academics, he says, agreed with every judgment that we judges wrote, what would there be for you to write about? As a case note editor for the journal that Maya mentioned, I concur, and I know that barristers and academics alike take enjoyment in this exercise of criticizing judgments. I think some of us might prefer a little bit less to criticize in recent years from some court decisions, but I think we're joined in this endeavor, at least, with academics and practitioners. Lord Dyson in the chapter then goes on to quote Lord Gough in the judgment in the Spiliada case. And Lord Gough had described jurists as pilgrims with judges on this endless road to unattainable perfection. But I think academics and judges actually, and practitioners have an even more symbiotic existence than just a shared pilgrimage. Academics do the vital research, which poor legal aid practitioners, to be honest, don't have time for, don't have the funding for, and sometimes don't have the skill or expertise to undertake. They contemplate over months and years. They conduct detailed qualitative field research and quantitative research, grappling with statistics to which some asylum and immigration legal minds may be ill-suited. I only speak for myself, no one else on this panel. Their research also helps to support litigation, casework, and policy recommendations, as Violetta was saying. Academics are country experts, witnesses in country guidance cases, I sit on the, in my role at ILPA, I sit on the Independent Advisory Group on Country Information. Eric came before us for a non-grilling earlier this year because—
Not published yet.
Yes, not published yet. Did a review on statelessness and country policy information notes, but we also regularly see academics come and review country policy information notes. Recently, we saw the one on Albania being reviewed. And these are notes written by the Home Office, and academics come and they present their findings, they debunk the myths in the notes, they review the methodologies, they highlight the gaps, the poor logics, the misunderstandings of other jurisdictions' laws, the missed sources often in foreign languages, not in English. And academics and practitioners not only cohabit, as Lord Dyson did with his wife, who was a legal academic, but they also inhabit the same body. Only yesterday, Sheena York, who's sitting right here, from Kent Law School, missed a board meeting of the Journal of Immigration, Asylum and Nationality Law because she was too busy writing a skeleton argument for a hearing. But our journal is also exactly that. It brings together practitioners and academics. On our board, we have both. It's a very practice-focused journal, but we want to see the academic insights. We want to see the arguments to see how we can advance the law. But more fundamental, I think, to my current work is that academics not only assist judges and practitioners, they also really help with policy. And that's really what I've turned my mind to in the last couple of years. They don't just say how the law could be interpreted, but they say how the law should be interpreted, or in fact, what it ought to be, how it ought to change. And that's incredibly helpful. And that crosses over entirely with what our work is in policy. And I should say that I think academics in my role at ILPA as legal director have been invaluable to that task. They have a much wider field of vision, I would say, than the vast majority of practitioners who are, especially in the legal aid crisis, are particularly busy concentrating on the minutiae of their casework, on trying to get things done to achieve justice for their clients. They don't have time to read academic articles in the main. They also don't have time to undertake that lengthy research that I mentioned. But not only can academics see the wood from the trees, which I think is really helpful, but they often also know arguments that have been employed, including successfully, in other jurisdictions. And that's really helpful because we practitioners, especially those of us only qualified in a single jurisdiction, like me in England and Wales, don't really know what's happened in other jurisdictions, don't know what's been employed successfully. And as an example of this, when I was briefing on the standard of proof in the Nationality and Borders Act, which passed last year, Lord Wolfson, who was then representing the government, decided to draw out Canada and Switzerland as these two other jurisdictions, highly respected democratic countries with a higher standard of proof. And it was actually David Cantor at the Refugee Law Initiative who was able to really help connect me with academics and practitioners in Switzerland and Canada, so that I wasn't trying to interpret this other jurisdiction's laws, which I'm really not qualified to do, but I could hear from them whether their standard of proof was aligned with what the UK was proposing in the Nationality and Borders Act. I found that in Canada, for example, a first instance asylum decision isn't made by an immigration enforcement agency like we have here, the Home Office, but by a judge at an oral hearing. And the balance of probabilities test, which is part of what was introduced in our standard of proof, applies to assessing objective evidence in light of the situation in that country. By contrast, there's a really nuanced assessment of subjective fear that a person may be incapable of recognizing, for example. And on the continent, including in Switzerland, legal traditions and asylum systems are, of course, entirely different. They're inquisitorial in nature rather than adversarial in the main. And the Swiss standard of proof has been applied in practice much like we apply the Article 3 of the European Convention on Human Rights real risk test. And so it was quite different to what was being proposed in the Nationality and Borders Act. Crucially, also, Switzerland has a single holistic test, and that was different to one of the problems we identified in the new standard of proof. And in the Illegal Migration Act this year, it was Conor Gearty at the LSE who helpfully wrote the little piece that we have in our House of Commons second reading briefing on the disapplication of Section 3 of the Human Rights Act in the Illegal Migration Act. And he mentioned it recently in Public Law Project's Judicial Review Conference, which again is another really good example of practitioners and academics coming together and sharing ideas and knowledge. In legal aid, it's been Joe Wilding who has really helped me cross this boundary between research and practice, who provides the constant necessary updates in research to argue for real change in the policy environment of immigration and asylum legal aid. So these are just a few examples off the top of my head that I jotted down while I was on the train here about some ways in which academics have been crucial to the work, especially in policy. But I want to end, if that's okay, on quite a controversial note. I wanted to talk a little bit about the difference between legal academics and legal practitioners. I want to suggest that legal academics are actually more liberated than us practitioners. They're not bound by our professional ethical obligations. They're not obliged to represent both sides of the case if bound by the cab-rank rule as barristers are here. If they're not instructed, they don't need to fearlessly represent the best interests of their client, including if they morally oppose the case. No, they can choose when and how to put forward their legal arguments. They can choose silence, and they don't need to rush to defend the other side. They also don't need to add to the inequality of arms, which I would suggest exists, the imbalance of power between the state and the migrant, the displaced person, the refugee. And yet, from a small minority, I would say, of certain legal academics, I see arguments that I think need not be made. I have no doubt about the necessity and value of academic freedom, and that's not what I'm putting in question here. The question is not whether a legal argument can be stated, but the value of it being stated, the strength of its merit. I don't intend to name or shame, but I think there were several eminent legal professors who supported the position of the government during the passage of the Illegal Migration Act this year. And I would say with that role in the academic sphere also comes responsibility. And I think we're all acutely aware of this. I know others embrace it, but I've said time and time again that I'm personally quite tired of the culture war, tired of people using the word activist to demonize those of us who represent migrants, and yet those advising on the exact same law on the other side are not painted with that brush. They're not targeted in the press. It's considered activist to employ human rights arguments or seek good faith interpretation, I would argue, of international legal obligations. But I leave this question, are they not activists, those lawyers too, those academics who seek to press the envelope of legal innovation in the name of integrity of the UK's borders, seeking to change law and policy also? Shall we not call them activists? And as we move towards fragments of writing, blogs, Twitter, X, whatever it's called, rather than peer-reviewed articles, a fair and accurate representation of legal arguments on both sides is necessary. And I think it's expected by us non-academics, because I think we see academics as independent experts. And I would argue even more so it's necessary for academics than for those of us who are instructed to represent on one side of the case. And I'll just leave it there.
Thank you so much, Zoe. There are already so many things I want to ask you, but I'm going to hold off until
I'm not naming and shaming.
Yes, that's true. I'll ask you that afterwards. But we're going to move on to Professor Elspeth Guyot now. So Elspeth, please, the floor is yours.
Thank you so much, Maya and Violetta. And it's a great pleasure to be with you. I'm sorry I'm not with you in person. This is one of those things that happens, but I really enjoyed your presentation, Zoe. And I must say, I think that what I'm going to say fits very well with what you've said. I certainly endorse everything which you have, which you've raised as relevant to my personal experiences. Of course, I came to academia via practice. I'm still a practicing solicitor. I've just had my practicing certificate renewed. And so I've always looked at academia as how it works with practice, that the study of law and the practice of law are both aspects which must be intertwined. And I'm going to look at three particular issues. The first issue that I want to look at is how do academics participate as practitioners? And here we see, in addition to the various ways which Zoe has mentioned, we see that often academics are invited by practitioners, usually at the senior level, to join in legal argument before the courts. And we see this both at the national level, usually at the higher courts, and we see it very frequently at the supranational courts, the Court of Justice of the European Union and the European Court of Human Rights. So we see a real overlap there. And we also see, particularly in the supranational courts, quite a lot of professors are appointed by their governments to be judges on those supranational courts. So often people who have been exclusively academics through most of their lives find themselves faced with a judicial role in some of the highest courts applying particularly human rights and EU law. The same is also true of the treaty bodies, but I'm not going to go there because the UK has not signed up to the jurisdiction of the treaty bodies to consider human rights complaints by individuals. The second thing that I would say about the intersection between academics and practitioners is the tremendous importance of the circulation of legal ideas. Often practitioners find themselves faced with clients with extraordinarily complex problems, with multiple facets which need to be addressed and need to be looked at, and with the duty to give advice to their clients of the multiple options and choices which they may be able to take. And in doing so, they often rely on or look to academics for legal arguments which may be at the cutting edge. We can see this is particularly the case in respect of the current litigation before the Court of Justice of the European Union on Frontex, that a lot of academic work was done preparing arguments, looking at arguments, examining the questions of jurisdiction and standing, many of which have been taken up by the lawyers. And indeed, I know in the Frontex judgment of the General Court, which is going on appeal to the Court of Justice itself, someone who is here today has been invited with another colleague to write a legal opinion, an academic to write a legal opinion in respect of the questions of how the law ought to be interpreted in respect of the individuals involved in that case. So often practitioners and academics come together to look at particularly difficult and complicated issues of law, where the practitioner may feel uncomfortable about running an argument which has never been run before and which is new and different. And I remember, this must be more than 15 years ago, we were facing some issues about EU law, migration, and the scope of provision of services under EU law. And it was so far from anything that was out there in the jurisprudence from the Court of Justice on service receipt and provision. It was so far from our way of thinking about our people service providers and what does that mean in terms of EU law. And I went to see one of the foremost professors on EU law who'd been working on services in her office. And she was very generous and gave me an hour. And for her, it was just so self-evident that obviously there was an arguable case. Obviously, the concept of service provision could encompass what we were working on. And indeed, the passing of the idea of service provision as a ground for a right of movement became part of the mainstream of EU law. So we see also the importance of transmitting ideas, and I would agree entirely with Zoe about the importance of the journal. One of our former master's students and I wrote an article recently, in particular about data protection and the personal data of asylum seekers, the way it's being collected, the judgments which we've seen in the court, the Information Commissioner's opinion, and the creeping in how the courts are beginning to deal with the question of AI. And when we were doing this, we were thinking very much about how we could assist practitioners to think a bit more broadly about what are the personal data protection rights which migrants and asylum seekers have, which are completely out of the thinking of the way in which practitioners in the Home Office are going about using this kind of data. So we're hoping that that will give rise to some ideas. And of course, our former master's student is now working as a legal advisor at one of the law firms, which is very active in the field of migration. And I'm hoping that she will take with her these ideas into her practice. The third area that I would like to cover in respect of the relationship between practitioners and academics is that around teaching. And I think we often forget that the foremost job of academics is to teach and prepare the next generation of lawyers, barristers, and solicitors who are going to be going out there and running cases. And what we teach in the classroom often will remain with them throughout their career, as they will remember, oh, I remember when Professor Moreno-Lax said X, and maybe that's useful for what I'm worrying about here, the issues that I'm doing there. Our role as teachers and the authority which is given to us as teachers to train the next generation of lawyers in the UK is an enormous responsibility, but one which we must take very seriously, because the people we are teaching are going to be the practitioners who will be deciding what kinds of arguments are going to be put forward and how they will approach their clients in practice, what kinds of things they're going to be recommending and suggesting. I think in the context of teaching, one of the things which all of us have worked at enormously, particularly those of us who are involved in the Borders Centre, is trying to ensure that our students are getting real life practice while they are learning. And Violetta has a wonderful course, which is where the master's students go out and work in law firms and in NGOs and with barristers to get real life experience, on which they are then required to theorize, imagine, and on which they will be marked on their essay. So very, very interesting and important program in terms of bringing together practitioners and academics. I would also say that we are tremendously grateful as academics to the practicing lawyers, and it's usually barristers, in fact, who are willing to make a bit of time in their busy careers to come and talk to our students about particular issues in immigration and asylum law. And I have to thank a long list of barristers who have very kindly come to courses I've been teaching to talk to the students and to inspire them about what is the possible. And Mark, you are absolutely one of the people whom I am most grateful to for always being ready to come and talk to students, irrespective of how inconvenient it may be. Though, of course, we do usually try to organize the classes to be down here at CCLS, so it's not too far from the bar. But I think it's a tremendously important part of the process and part of learning how to be a good practitioner and how to be a good academic, bringing together all of these strands, the teaching, the duty to produce legal ideas, and the obligation to assist the practitioners when they call on us to assist with them with specific cases before the courts. Thank you very much for your attention.
Thank you so much, Elspeth. I think you've given us a lot to think and talk about there. And you've mentioned Mark already, and it's his turn next. So over to you, Mark.
Thank you very much. So I'm going to talk about the role of academic opinion in refugee courts decision making primarily, and also the use of practitioners made of it. So, as Article 1 of the Statute of the International Court of Justice puts it, the writings of the most qualified publicists of the civilized nations are a legitimate source of law, and so it's been in the field of refugee law for a long time now. Judges have regularly reverted to refugee law scholars for inspiration. I suppose that as time has gone on, they've become more confident in themselves and less likely to revert. I mean, in the 90s, Professor Hathaway's work was a standard reference point in the UNHCR handbook. In fact, with the only 2 original reference points that anyone really had. But obviously, judges, as time has gone on, probably feel that they've got a lot more expertise. And Hathaway's second edition of his Law of Refugee Status has hardly been referred to, whereas the first edition was absolutely a standard reference point for all the common law courts. Lord Muskell in T talked about the ambit of exclusion clause in national security cases in the mid-1990s, actively regretted the lack of scholarly material that was put in front of him. So one wonders how much there really were out there in those days to be found. And what academic opinion does, I mean, I suppose it sort of provides two roles. One role is to tell us what the law is, and of course, I think the opinions of the qualified publicists is intended to be admissible only in terms of telling one what international law is. But of course, as Zoe remarked, it may also have a value in terms of telling us where the law might be going. So, for what purposes has it been deployed in our courts? One opportunity, or one possibility, is the greater expertise, exactly the point that Zoe made earlier. In fact, actually, is at the time and depth of study available to academics gives them a broader reservoir of knowledge to draw on, and of course they're not under the same pressures as practitioners are under. It's sometimes said, I've seen the Upper Tribunal remark upon this once, it's sometimes said that academic opinion, of course, is softer in some senses than legal judgment because it isn't subjected to the same degree of adversarial approach. That may or may not be right. Academic opinion also gives us an opportunity to see if there is an international consensus on things, and indeed, before the UK signed up to the European Union regime, the qualification directive regime, and the common European asylum system, our judges had something of a conversation with the courts of Canada, New Zealand, and Australia for several years. Who knows that perhaps now we've departed the espace juridique of the European Union, maybe that conversation will resume. But I think it's notable that refugee law has been much less active in Australia, New Zealand, and Canada in the last decade than it was in the previous 20 years. Another purpose that it can use is simplifying work that would otherwise be almost impossibly difficult. I think remember that back in the days of Adam and Noor, the House of Lords and the Court of Appeal despaired when they looked at the Travail Préparatoire of the Refugee Convention and said it was simply incomprehensible. But Paul Weiss, in the early days of academic refugee scholarship, wrote, he summarised the Travail rather well, and in fact his opinion is drawn on by the Court of Appeal in the Rwanda litigation just this year, and just working out the ambit of Article 31 of the Refugee Convention. Something scholars have to watch out for is inconsistency with their own writings, and I think Guy Goodwin Gill had a bit of an issue there when he wrote an opinion in Ravenko, which the Court of Appeal found his previous published work was surprisingly silent on, and he was writing about the ambit or the statelessness protection found in the Refugee Convention, suggesting it was much broader than anyone else had ever thought. I suppose the greatest triumph of academic opinion in refugee law has probably been the adoption of Hathaway's test about persecutions definition. being a sustained or systemic failure of state protection. That seems to have found favour, certainly across the whole of the Commonwealth jurisdictions. So what specific uses have we seen of it in recent times in international protection law and enforcement tribunal as well? In the KH Iraq litigation, the first attempt to work out whatever Article 15C of the Qualification Directive actually meant, that there was some academic opinion relied on. Svitskeboya, the Dutch academic, his work was certainly cited quite heavily to the tribunal. And of course, that was a tribunal that was extremely inclined to follow academic opinion. Two of the panel, well, all three of that panel were senior academics, in fact, in their part of their careers. And unfortunately, the Court of Appeal was to take a much less creative view of the ambit of 15C. Professor Chinkin produced an opinion in some of the Somali country guidance litigation a few years ago, talking about the extent to which armed militias could be relied on by Western states as a way of procuring protection for asylum seekers having to cross the territory of Somalia. And the final example, Professor Goodwin Gill in GP North Korea, he wrote a slightly more unusual opinion in that he commented both on the terms of a readmissibility agreement between North and South Korea, and also he commented on some recent Court of Appeal judgments and their compatibility with the Refugee Convention, none of which went down terribly well, I think, with the upper tribunal in that case. So there's an example. There's an example of the deployment of academic opinion in refugee law. Thank you very much.
Thank you so much. I love getting some actual real life examples. It's very encouraging for academics in the room, I think. And we are going to go to Ellen and see what she has to say.
Yeah, thank you so much. The discussion has been incredibly interesting, I think, especially because I am an early career researcher, which means that I've kind of dipped my toe in all the different fields at the moment. I'm personally all the time trying to work through whether or not I prefer being in academia, whether I like teaching, and whether or not I'm going to make use of being called to the bar eventually. So in general, I guess what I kind of want to talk about is it's going to be taking a little bit of a different approach, a reversed approach, not least because I am a PhD student, but also because I work quite specifically in the context of the Greek hotspots, and therefore in also the EU context. But I think that context and my experience with the PhD research and doing empirical research and work with an NGO specifically shows a little bit about the circularity of this relationship between academia and practice, and particularly the fact that you could position the start of my PhD project from the dissatisfaction I found in academic literature and then going to practice, or you could find the start of my project in doing practice prior to my academic experience and wanting to delve into the questions that I found from practice in a lot more deeper context and through the resources of a PhD program. What I think ultimately comes out from this specific context is that the circularity in particular benefits from the systematic approaches and finding systemic arguments from practice that tends to be, particularly in the context of working for NGOs, or casework NGOs, very specific on individual cases. So I started my work with the organization I Have Rights last year, which is an NGO that operates on the island of Samos in Greece, and I undertook asylum casework there. And the purpose of doing this was to be able to understand what practical barriers people encounter when they're trying to access the legal system in the EU, in the Greek hotspots. And what I found prior to this was that the academic arguments tended to lean into conversations around exceptionalism, and they would lean into positioning this as a space that almost seems to operate outside access to rights and the regular rights that should be guaranteed in the EU space. So what I tried to do through this practice-based approach was to look at and contest this idea by instead looking at how do we encounter and negotiate with how law operates in that space, and how NGOs are constantly undertaking tons of different avenues to be able to litigate for individual people, and broadly in the context of the closed facilities. So I want to focus on the specific example of the closed facilities and what the organization, what I have been doing in assisting the organization with regards to detention. So the closed control access centers that opened up in the Greek islands, the first one being the island of Samos, was started in 2021. So the bigger context for the hotspots is that in 2015, people who would arrive to the islands in Greece and Italy were required, or they were placed under a geographical restriction to those specific islands, which meant that they had to undergo identification procedures and likely also their asylum procedures on those specific islands. With the closed facilities coming into place in 2021, they were responding to what was perceived then as being a lawless concept that people were living in tents. Now with the closed facilities in 2021, they were placed in containers, and in Samos in particular, they were placed in containers surrounded by NATO-grade barbed wire fencing and barriers between each various section in these facilities. They have 24/7 CCTV footage. They are surrounded by Hellenic police, monitored by Hellenic police all the time, as well as Frontex, and the private security company G4S. There's a lot of different aspects that involve different kinds of rights that would be relevant to the EU. The detention concern is primarily this argument that this facility amounts to unlawful and arbitrary detention. Because the CCAC is not considered a detention space, it's just considered accommodation. In fact, when they opened it, they said it was a more humane approach than the tents that people previously lived in. But now the facility basically restricts people to these containers that are surrounded by barbed wire fencing. In Samos, on island Samos, the CCAC is located 8 kilometers outside of the main city where all of the NGOs operate, which means that people are relying on a bus that goes 4 times a day, that costs money. They pay money to get on this bus, and if you don't take the bus, it's an 8-kilometer walk through the hillside, the mountainside, which takes about 2 hours for people to do. So in that sense, it's very isolated. Another sense, when people arrive, they're required to stay in the facility for at maximum 25 days to undergo identification. In practice, it extends far beyond that. At certain points, they still had the mandatory quarantine until November when I was there last year, despite the fact that quarantine measures and COVID measures ended in May in Greece, which meant that people were held reported length of time up to 40 days without access to medical professionals, because on Samos, they haven't had a permanent doctor for over a year, and without access to legal professionals in this space. So I Have Rights has been undertaking a lot of different forms of litigation to ultimately try and argue that this amounts to detention. People are handed restriction of freedom orders, and they're told that, oh, you can request permission to leave, you can take this bus, you can speak to these different people. In some ways, they seem to be at a surface level fulfilling certain checkboxes, but they are not detaining people. They're really just restricting people to this space. And the benefit of introducing legal arguments in this space, and what I've been trying to do for the last year, is to show that ultimately it's these very practical measures that accumulate to be able to construct detention. And that all of these smaller details, these minor details, help us show how this amounts to unlawful and arbitrary detention. And so that's where I really see this benefit of being able to exchange this academic arguments and the practical experiences. As you kind of was mentioned, this does mean that sometimes I come into that space with a little bit, some arguments that maybe don't necessarily fly. They don't really find beneficial. And when I was doing casework, for example, I think that was particularly tough to not be able to think about what ways we can push the boundaries on every case to make sure that people would be able to benefit from refugee protections. So there's some upsides and there's some downsides to be able to negotiate that. Yeah, look forward to the questions.
Thank you so much. I think that's a really, really great insight into sort of the practicalities of how research and practice converge. So yeah, very excited for the discussion after. But last but not least, we've got Eric.
Well, thanks, Nanda. I'm grateful to Queen Mary for inviting me to be here. The questions I was asked to address were whether I engage with academic work in my professional life and how practitioners can benefit from legal academic work. My primary work began focused on refugee law, but has widened to migration law, to many aspects of human rights, to laws relating to citizenship. I do engage fairly extensively with academic work on essentially two faces of my professional work. One in relation to citizenship and legal concepts affecting citizenship. Secondly, academic work relating to refugee law. But I do worry that I'm very far from typical, and on average over time becoming ever less typical. My worry is that interaction with academics in professional life are focusing on some of the work I do, which is now essentially financed by other work I do, rather than being my main occupation, is increasingly something that's present and beneficial, but happens at a very elite level, and that, as it were, at the ground level of the work done by often relatively junior barristers or even qualified caseworkers in asylum cases, there's the overall pattern is disconnection, and that there's really quite a serious level of disconnection, which I'd relate to a couple of events. But my biography, I spent 15 years as a student, when you take into account some time as a very extended part-time student, having to carry over dissertation at one point. So I'm grateful to St Andrews, to UCL, to even to King's, and also to LSE, for all of that, and to University of Toronto at the start. I, like many people coming into refugee law, my background is in fact not having done an undergraduate degree in law, but having done an undergraduate degree that involves a lot of Roman economic history and the study of shipping patterns in the 8th century Mediterranean, which I think has served me very well, albeit I don't think that's in favor with our current government. That said, so I'm someone who, frankly, if I came into the harbour on the ship, would probably walk up to the university to see what was going on. That's just, as it were, my mental setup. That's coming from family and society. So it's always been natural to me to be a member of the professional bodies associated with my area of work. In this case, primarily ILPA, but also the Admin Law Bar Association, the Constitutional and the Municipal Bar Association, and to interest myself in relevant learning. But one thing that is distinctive about me with Mark, and if I can put it this way, our generation, is that one, we came in at the time when the law in terms of refugee law was not fully developed in areas that affected everyday work by practitioners. In refugee law, you can say that 99% or more of the cases that have to be considered are concerned with one of two questions. Indeed, 95% are just about, is X a refugee? Maybe 5% plus are about, are we the country that has to decide whether X is a refugee? You know, or can we leave that to someone else? And so the focus is really quite narrow compared to the ambit of academic work. And practitioners should be grateful to academics for covering all the stuff that isn't going to turn up on a regular Tuesday in Taylor House. But there just isn't much engagement with practical day-to-day work there. And like Mark, you know, I came in at a time when the handbook, with all its strengths and also its flaws, was a large presence. And when Hathaway and Goodwin Gill and via and through Hathaway, the Travel were a major source. Now, Hathaway was essentially the heir to a man called Abdullah al-Adsi. I've never met al-Adsi, but I have a great respect for this because he wrote one of the best books about the refugee definition in, I think, the 60s, at a time when there was really barely anything and you have him pull stuff up from district courts in Bavaria, you know, because there's so little jurisprudence. And so at that time, there had to be a reliance on a broader learning because there wasn't a jurisprudence. Now there is a jurisprudence, and thanks to the web, a lot of that jurisprudence is available and indeed presses in online. I should say also that I have little outlook for my academic inclinations until the foundation of the refugee law initiative, and that much of my chance to interface, if I can break my usual pattern by using noun as a verb, was through the refugee law initiative, the Refugee Studies Centre at the University of Oxford, and various endeavours for which UNHCR can be thanked. But let's move forward. Now, I was lucky to start in approximately the time when Mark and I had started. That was, as it were, a time when people like Francis Weber and others were getting really important things decided, whether things were really being locked down. Since then, there are reasons to worry that skills may atrophy. One thing is that if you were just focused on the refugee definition, bits of it have really stopped mattering since the Human Rights Act came into force. Your task as an advocate is to get your client out of the building you're both in with as little damage and as much damage as possible. It's not unless your client expressly wants you to prioritize some general interest over the client's own, which is a rare experience. It's not to argue an academic case. And thanks to ECHR, some of the trickier concepts of the Refugee Convention, like convention reason, like agents of persecution, have effectively ceased to matter in the UK because you simply succeed under Article 3 and you get the status that's the same as you've got with refugee status. The only thing that you can say against that is that you don't get a travel document under the 50th Convention, but increasingly you can say there's little prejudice in leave on the Article 3 basis rather than under the definition. In addition, of course, along came a new government in May 2010. We know which party that was, but I won't say it. And then you had you had restrictions on legal aid. So the standard rate, the last time I knew the standard rate for doing a fixed rate asylum case was £302. Now, at a time when students had full grants and maintenance loans, or maybe it was the other way around, or maybe it was all just grant, and scholarships for the bar and so on, and London accommodation was cheaper, that was bearable. But effectively, the minimum requirements to get into the bond are a 3 or 4 year degree, during which most British undergraduates will have built up a large load, a lot of debt burden, you know, probably at least a 1 year postgraduate degree, a period of looking for people of indefinite duration, holding various jobs calculated to move on towards the destination of getting it. Still, along the road to that, some unpaid internships and stages. And so there are really quite strong reasons why the pool of people who can be brought into the profession, you know, ready to do fixed rate asylum work, for which often you're not paid for 1 or 2 or 3 years. The solicitor may not last long enough to pay for the work. You know, is in my experience with control legal representation and the main form of funding for appeals, sometimes a real consideration. So, and you have, LASPO, the Legal Aid Sentencing and is a Punishment of Offenders Act 2012, and you have a ratcheting down of legal aid since. In judicial review, you have rules whereby if you're refused permission to apply for judicial review, you're meant not to get paid. Of course, unless you're working for the Secretary of State and receiving judicial review, in which case you would get paid if you didn't get permission. And you don't get paid even if the reason you're refused permission is that on the day before the judge makes a decision on the paper application, without anyone telling you, the Home Office does what you have sued them to do. And you then have a lengthy secondary argument which may end up itself being unfounded without costs. So that's not an attractive situation, and you can understand how I can understand, because this isn't, as it were, a personalized complaint. This is a complaint about the world in which I practice at a privileged level of experience and establishment. You can understand, you know, the pressures on junior members of the profession. And one of the challenges is to make sure that at a non-elite level, in cases that, you know, won't make it to the Guardian or on the other side of the Mail, that cases that will make it into the newspapers, you know, get representation by people who have, you know, the leisure. I'm sorry, leisure is the wrong term. Perhaps the O2, if one would, who have the resource to seek to build the sort of wider knowledge that would enable them to be you know, a better market, if I can put it this way, for a more consistent, you know, interaction at a, well, let me say a pre-AD level. So that's my concern. I hope that doesn't sound negative. I mean, there are positives in that, you know, we still have legal aid, we still have a system of adjudication that I think broadly, you know, tends to work better than not having a system of adjudication that has actually some quality in perhaps not getting you the right answer the first time, but in giving you enough chances to get the right answer out if you're adequately represented, you know, and the circumstances are right. I mean, I would say, being part of the chambers where, you know, the person in the next room is an international shipping lawyer, that, you know, interaction is, and indeed the head of our shipping team is a former professor of shipping law at Southampton, that interaction, I think, varies field by field. In administrative law, I think it's relatively, you know, more common at a level that runs through, the seniority structure than it is. And we can think of this as, perhaps a challenge to address in immigration, asylum, and border laws. Thank you very much.
Thank you so much, Eric. Really, really good to get some insights sort of into the systemic problems that are at play there for practitioners as well. I'm sure lots of you have questions, so we're going to come to these in a minute. And people online, please do type yours into the chat. I think that's going to be the easiest way to do it. But I would like to kick things off by asking you, I suppose, for some practical advice. So all of you, I think, sounded quite positive, at least in theory, about this idea of academic work and practice informing each other. But as we've heard, there are obviously also issues there. So Zoe, for example, mentioned the time constraints. Eric mentioned the general situation with the legal aid crisis and how difficult it is as a result, especially maybe for younger practitioners to actually be able to engage with academic work. Then Mark sort of mentioned that maybe practitioners look to, I suppose, the most eminent scholars. And Elspeth mentioned that, when you're perhaps a little bit more senior, you do get invited to present your arguments to practitioners. But I suppose my question is, how can we make this a more common occurrence? So can you think of anything that would enable us to actually make academic arguments, which could be valuable and interesting, more accessible to more practitioners? So maybe not just academic writing by the most eminent scholars who, will be very well known already, or who will get invited to every event, but perhaps also more junior scholars like Ellen and myself, and maybe others in the room. So, Ellen, for example, do you have any particular plans how to get your argument across to people who might implement it? Or are you planning to maybe take the space somewhere yourself? And maybe the rest of you, if you have any ideas, how could we come together and sort of exchange more effectively? I would be very interested in that. So maybe we can go in the order of the speakers and start. So that's okay.
I would just add my word of caution at the end about certain legal arguments, which I don't think are quite so helpful. I think one issue, and it's related to what Eric said, it's not only time, it's also money. A lot of providers, a lot of practitioners don't have the money to get a subscription to many of the journals. They don't have access to it. They're not students anymore. And if they were students or briefly left their studies recently, soon in the first few months, if not year of practice, they lose access to the journals that they have. So we do need more that's open source, more that's free, more that's available. That's certainly one thing, accessibility. But there's also this sense, at least especially on the policy side of things and litigation, whether that's strategic litigation or whether that's your ordinary day-to-day litigation in immigration and asylum, where we need things to be coming out as they happen to be relevant. And this is a huge issue, I think in the past more so than now, where academics were writing a year plus after something had been relevant. And by then, you have KCs who have grappled with it, who have written things on their little WhatsApp chats and in chambers. There's been discussions. And so I think academic arguments need to happen and be available contemporaneously to those issues being relevant. And yes, I did my little rant about fragments of writing and X, and I'm no fan of Twitter, but I'm on Twitter, and I think others are, because it's a necessity. Because otherwise I would be isolated relatively from the academic field, and that's even with academics who are ILCA members. But at least I can see what their initial thoughts are. The problem is then when those thoughts are not really backed up by the legal arguments, which you would see in a peer review article. And so we need good legal arguments out there, and sometimes you can find them more easily in peer review journals. The problem is they often come too late. And so it's this difficult balance. I don't have any solutions, but I think if they were more freely accessible and easy for practitioners to see too, and on forums and sharing networks like Twitter or X or whatever it's called now, it would it's helpful and easy to access them there. And I don't know if we create other ways or we have more open access publications once those arguments are available so that people can see the thoughts behind them before they plead them in their cases.
Yeah, I think that's really, really interesting and something that we for sure also talked about in our workshop in June, the fact that there are paywalls and people can't necessarily access it. But I think this point about stuff coming out sort of after the fact is also really, really interesting and not something we've really discussed before. So maybe that's actually an argument in favor of writing a blog post first and then a peer-reviewed article second.
Yes.
So that's actually really interesting and really helpful. Elspeth, do you want to say something?
Yes, indeed. I think your question is a brilliant one. How do we bring these worlds together at the level where the more junior scholars have perhaps the most interesting ideas and the most groundbreaking ones? And I would say that in my experience, a busy immigration or asylum practitioner is someone who is working very long hours, putting in, getting up very early, getting into the office an hour before everything starts, staying late, and is very and practitioners are very protective of their weekends. My experience of academics is that the intensity of work takes place at a different level. So for instance, teaching can be extremely tiring. So you finish doing a 2 or 3 hour course and you think, I'm just going to fall into a heap on the floor. But then it also stretches into the weekends. But I think there's greater possibility for academics to reach out and find the practitioners than it is for the practitioners to reach out and find the academics. And here I think, and I hope, Zoe, that you don't mind me saying this, I think ILPA is one of the places where the engagement of academic members are encouraged to be part of ILPA, can join the working groups and take part in helping to formulate ideas and policy. And I know for the gazillions of years that I was a co-chair of the European Working Group, some of the most fruitful periods of the working group were when we had academics who came regularly to meetings. So there would be a number of them. Steve, of course, came for quite a while. Valsamis did. Bernard Ryan did. There were a whole series of people. And just by being in the room, as we were discussing what the practitioners do, and the tendency of those who work in solicitors' firms is to talk endlessly about how inadequate the Home Office is, and they never answer anything. And if they do answer it, they send you the answer to somebody else's question rather than the one relating to your client. But all of a sudden, if you have academics in the room, they raise the tone, and all of a sudden it becomes more than that, just a question of, I can't get the Home Office to answer my calls. It's about what is happening with the funding, where are the fees going, and why are they not these ever-increasing fees, and why are they not going into this? What are the justifications and the arguments which can be made about the fees in respect of various work? So I think that it's really for the academics to reach out to the practitioners and find them in the places where they go. And of course, the other places, of course, the subcommittees of the Bar Council and the Law Society are places where you find them. And often academics can be incredibly helpful because these practitioner organizations are endlessly being asked by parliamentary committees to produce submissions of X, Y, and Z kind. And I know, Zoe, you spend most of your life working on this. But if you had some academics that you could perhaps shovel out some questions to help you, that would also be a way for younger academics to make their names and get in contact with the practitioners.
Yeah, thank you so much, Alfred. I think this is a really nice suggestion, and I would love to hear from the practitioners who are here how they would feel about academics reaching out to them with ideas. But of course, we are also trying to reach out to practitioners with events like today and the event we had in June. So at that one, we actually had more junior academics present some of their legal arguments to the practitioners, which went down quite well, which was nice. So I think it's for sure a really, really nice idea. And Violetta commented in the chat that maybe having an ILPA, I don't know, a journal for immigration, asylum, and nationality blog, where academics and practitioners could exchange ideas could be a nice idea. So maybe that could be something we could explore going forward, which would be really, really cool, which sounds like a really, really good idea. Shall we go to Mark for a comment?
Yeah, briefly, I'm not really going to do more than echo what Zoe has said, but I think really so. The best platform to engage with is probably LinkedIn, that had a professional feel to it, unlike the more deranged quality of but in terms of getting your stuff used by the courts and by practitioners, the two critical issues are topicality and relevance. So, firstly, you need academic opinion that is published quickly enough, to beat the cases into court. And the reason why Hathaway was always so spectacularly successful in being cited, and literally cited 3 times as much as his rival Sigmund Gill, is that he writes about what matters. When Hathaway wrote in his first the law of refugee status, he writes about the refugee definition, which was then one of the biggest issues to be litigated for the next 20 years. Almost everything he wrote was quotable and citable and on point, in a way that a lot of academic work isn't quite on point with germane issues. So I don't know what the next big issues are going to be, but I mean, two possibilities, I suppose, are the 23 Act. There's a lot about 23 Act, isn't there? And its compatibility with Article 31 Refugee Convention, because I think practitioners advance arguments rather prematurely on the random litigation, which Article 31, which have been rejected vis-a-vis Article 31. But obviously, the 23 Act is far more controversial than the random policy. The Article 31, but also a bigger issue really is that what approach is to be taken to refugee law and its interpretation post Brexit, because like we've been following the canons of European Union law construction for 16 years, better or worse, and now we have a very interesting situation that the 22 Act has taken the language of European Union law, but removed it from the soil which previously nurtured it. And so, what are we to do? How are we to approach it? And that's a huge academic contribution would be useful. Thank you.
Thank you so much. And we've already given people some ideas for blog posts tomorrow, so that's amazing. Ellen?
Yeah. Well, I mean, I guess I've really benefited this year from having such a close relationship with a legal organization and the litigation work that they do. And that means that I've been able to include my academic arguments, some to an extent, in some of the things that they've been doing. But I think both for myself and for legal advocacy organizations, especially, I guess, maybe for the junior organizations, the junior academics, we're both struggling with time and resources and funding to be able to do these things. And so I wrote down the different things that the organization has done over the last year as well with regards to just specifically this issue of detention. And a lot of that work in the litigation is through lots of different means, both through kind of more advocacy means than maybe more litigation means. So we've done a report on detention generally. We did a Rule 9 submission on the MSS implementation with the Court of Europe, and then there's been an input to the Office of the High Commissioner of Human Rights, several interim measures. There was several appeals then from various cases and negative asylum decisions. Submissions to the EU Ombudsman on the special inquiry into fundamental rights they've been doing, complaints to the EU and Greek Special Rapporteur. And then at the moment, I'm working on an article that's going out to the Rosa Luxemburg Institute. And that's on one issue, and there's been very little movement on this topic. In fact, it's gotten worse in the last couple of months. So in a sense, just on this one topic, it's exhausting both the time and energy and finances of myself as a junior academic, and then the organization that has to try and get funding to be able to undertake all these different pathways to litigation. So it's tough, I think, with even when you do get that connection between academic arguments and litigation, in that it's a lot of time that goes into it. And for academics, because we have such a flexible, somewhat flexible lifestyle, it becomes easy to kind of overcommit to various different things. So
I did have to smile a little bit more earlier. People said academics have so much time to actually do in-depth research. I was like, do we though? Yeah, I see that you are absolutely doing that and like looking for these different fora, which is amazing. So I think this could also be a really interesting way to exchange on with academics and practitioners of what different fora can we try and go through in order to actually get our arguments to get adopted. So I think that's really, really interesting. And Eric?
Yeah, nothing, thank you.
Nothing. Okay. In which case, let's see if anyone in the room has any questions or online. I can't see anything in the chat currently. But I think Shauna maybe had a contribution.
I've got quite a lot I'd like to say, if that's
Please do.
okay. And I would say I'm possibly from the generation which was referred to so politely by Eric, and you know, have a long background in this, because I started out in a law centre, and you start working in a law centre and you immediately have the plan that your casework is going to change the world. You know, that is the ambition of it, and so you're always looking for something which is going to raise a test case or strategic litigation. And so in the first 3 months of my law centre, we sued the local authority. We took some, I don't know, some unknown court procedure, I think it's some difficult thing, and nearly got our grant cut straight away. That was not what they wanted us to do. And so you think that by your casework, you might change the law, you might even change policy if you do enough of it. And I've been involved in quite in large pieces of litigation on support for asylum seekers. That's one lot in the 90s and another set of litigation in the 2000s. But since the last 10 years, I've been at the Kent Law Clinic, where I was actually funded to do casework and teach students and do academic work. And I think I must be the luckiest and most luxuriously appointed person, you know, because to have that as your job, because everything feeds into the other thing. And so you're encouraged in your cases to think about the strategic implications of it. And you're encouraged with students to inspire them, because the students work on the cases in the clinic. Just thinking about what Elspeth said about this, getting students to come in and witness people doing casework. Well, they're supposed to actually do it. They're supposed to actually do it. We supervise them. Yeah, there's and then obviously the academic writing is supposed to come naturally out of the issues that are that arise in the cases. So in the clinic, we had a colleague of mine wrote an article about precariousness, which went before the Supreme Court in Rupert, and they said very politely, well, we have Richard Warren's article before us, but we decided not to follow it. And they're wrong. I mean, they are just wrong. It's just terrible. And I've concentrated on concepts like retrospective impact of law. For example, in deportation cases, there's a case called Abidoy, where a man committed a crime, served his sentence, had a deportation order, won his appeal, lived in the UK for a very long time, and then suddenly was served with another deportation order. And the Court of Appeal said that's not retrospective. And I would just say they are just wrong. So that's one of the things I wrote in that article. Another thing that I'm want to write about and think about is the impact of having the burden of proof on the applicant. Now, that's in the Refugee Convention. I think it's absolutely deadly. I think it's completely catastrophic that the burden lies on the applicant. And I think I'm not, I wouldn't say I'm a refugee lawyer, I'm an immigration lawyer, and I look at the corrosion in immigration decisions of the burden lying on the applicant. You know, where the Home Office can just log in some kind of fancy of their own, like that child might be the child of the father and the mother's sister. Who knows if they've met? Who knows? And then, you know, and then the person loses their case. So I think my point in relation to the questions that have been raised is I found trying to move into academic writing how and especially when I wrote my book, how almost no writing, academic writing there is about immigration law as opposed to refugee and asylum law or migration theory. And so there's plenty of academic writing about the rights of the migrants, almost as if the migrants floating above the surface of the earth, and not enough about their experience when they encounter the 65 million British people who look at them on a cold beach and say, well, what do you do? You know, and there's not much writing about the implications for democracy or something like that. So I think Elspeth said there's plenty of elite academic writing of a level that can go before a very senior court to examine you know, a very specialised proposition. But I can't remember whether it's Eric or Mark who said in asylum cases in Britain, the main question is credibility. And if you try to write a skeleton argument with something that you have weight in it now, the court would just say, shut up, you know, we're not interested in that. We're literally not interested in it. We want to know, are you from Eritrea? Or are you, you know, we don't believe, you know, that kind of thing. So I think there's quite a lot of academic writing which is about migration, which doesn't have any resonance with practitioners at all. And I found that as a practitioner, and you know, I've been in big conferences where people have talked about those things, and they've said, well, we could just ask the Home Office to do this, and you think, no, you can't. You know, have you ever seen an immigration case? Have you ever read, you know, anything? And a lot of academic writing is very, very distant from reality. But at the level we're talking about, I think all of the suggestions could be followed. More meetings like this, more conferences which specifically try and invite practitioners and academics to come and talk about specific legal issues which are likely to become of interest. And then there is a huge problem of getting actual practitioners to be able to afford the time and the money and the space to come to these discussions. Because I think these type of discussions are the best thing to air our arguments. But if you are an academic who has recently written to legal aid lawyers and said, will any of you be interviewed, or will any of you like to answer my questionnaire, or will any of you do this, and got a resounding silence, well, you know, people should know why, you know, because it's just not possible. I mean, even we in the clinic get invited to things, and we think we just haven't got time to respond to that. So somehow or another, and I don't know, certainly our university, you know, is practically bankrupt, so it's never going to offer money to things like that. But no, seriously. But I think that somehow or other, for journals, for conferences, these sort of things, if there's a financial cost, then we have to enable practitioners to come as if they're from tiny charities or whatever, because otherwise they can't possibly.
Thank you. Yeah, of course. I think after hearing everyone on the panel, and something that I was thinking about before as well, is this issue of sort of strategic litigation as being the elephant in the room. And you were talking quite a bit about it, Ellen. And I think for everyone, it's the sexy thing to do. It's a thing that's well paid. And even for academics, the thing that the vast majority of academics are writing about, as Sheena was saying, it's not your basic day-to-day grunt casework, or even your appeal in the first tier tribunal or under the IMA, the upper tribunal. The types of things that academics want to write about are things that are happening in the more elite, or at least the higher courts in the UK. And those tend to be strategic litigation issues. And so for the vast majority of us practitioners, who aren't doing strategic litigation, we don't, I think the vast majority of practitioners want the claim to become academic. And by that, I don't mean academic in the sense of a journal article being written about it. They want the Home Office, as Eric was saying, to simply grant the claim. And so for the claim to be academic, that is the best outcome for their client at the end of the day, not the continuation of litigation, and whether that's paid by the public purse or by the client privately. They simply want the end of their case and the resolution of their status so that they can finally make the UK their home with a little bit more certainty than they had before. And so a lot of what academics are writing about doesn't affect if it's a pyramid, the vast majority of work that's being done on that bottom layer of the pyramid. It's about the top layer. And yes, there are those higher court cases, those strategic litigation cases in which academic arguments might be useful, but I think they're much less likely, as Sheena was saying, to be employed in your skeleton argument. And I don't know, Mark, how happy you would be if Hathaway was in a skelly before you in the first year. I always got told they were too long anyway, and I wasn't quoting Hathaway, it was just relevant case law.
Yeah, I think most judges think an argument should be more of a tweet than a blog post.
Oh dear.
But I think this is interesting because maybe if there was a blog where we could exchange views, maybe practitioners could also tell us what they would like us to do research on. And I think this would be amazing if practitioners could say, actually, this is an area that is underexplored, and you did give some ideas earlier, but it's really sometimes hard, I think, to judge for academics what would be useful in practice, even though we are very much asked to do impactful research. So I think that would be a really, really great way to exchange. Let's take some more questions. I think there was a hand in the room earlier, 2 hands in the room, and I also have 2 questions in the chat. So maybe we can collect, is 4 questions okay? 4 questions, and then see if we still have time for more. So there was a hand there.
Yeah. Hi, my name is Tamara. I'm from the LSE. I'm actually a fellow in public policy, so I don't really work on the legal side, but I found this talk really interesting. It really kind of resonates with this concept of 2 communities that we have, that we study in public policy, between researchers, academics, and then sort of practitioners and policymakers. And I've heard a lot tonight about how maybe practitioners should tell academics what they want, and there's sort of this distance between academic writing and what practitioners need, and then there's the time issue. We want writing now that's relevant and citable. But I was just wondering if maybe we could reflect on what might be some of the downsides about for academic writing, that if it's sort of, I mean, I don't know if it applies to the legal sense, but in public policy, this is often sort of seen as a negative thing, because we're sort of writing to what practitioners want or need rather than what we think is the right thing to be sort of researching on. So I don't know, maybe we can reflect on the other side of this point.
Yeah, very interesting question. Thank you very much. And sorry, what did you?
Yes, my name is Marianne Chandler, and I'm studying the law. Recently, I worked at Stilton, so I was a colleague of Zoe. But I wanted to ask, I think obviously a common theme that emerges is the issue of funding. I was going to ask, of course, academic research is supported by grant funding. That's also the case for lots of legal practice. Many charities and NGOs are supported by different funders, particularly in light of the legal aid crisis and indeed the restrictions on the scope of legal aid. I wondered whether the panel is aware of any funders who might be open to funding work that would foster greater collaboration between academics and practitioners, or whether in your experience, your knowledge, the funders in academia and in practice are quite distinct, and whether there would be value in trying to persuade the funders in these areas to work together and to collaborate more.
Very interesting question. Thank you very much. And I'm just going to read a question out from the chat, which is from Richard Hopkin, and it's to Eric and Mark specifically, if I understand this correctly. So it says, Mark, you alluded to this in passing by mentioning the COA's differential approach to expert evidence in the case. But can I ask, do you think that the England and Wales Superior Court judge's approach to expert evidence in general affects the use of such sources by practitioners? And then there is also I think this is more of a comment from Denise Venturi, who says, thanks to all the speakers for your interesting inputs and for the discussion, and she's a PhD candidate in law in Belgium. And she's worked as a legal practitioner before starting the PhD, and this believes that academic institutions and universities have a key role to play in framing this change, and they can help bring together practitioners and academics, for example, through dedicated roundtable discussions, today, where researchers can present their topic to practitioners and perhaps work together on a case study. So a more proactive role by universities can help overcome the difficulty practitioners have in reaching out to academics and vice versa. Yeah, absolutely agreed, Denise. And I think we are trying to kind of facilitate that kind of thing. And maybe next time we're going to try and have another event where academics present some more research, because that was really, really interesting. And Richard has clarified that he's talking about expert evidence for academics. Okay, so shall we just take these three questions for now? So maybe tomorrow's question first on sort of the downsides to academics sort of responding more immediately to problems.
So maybe dangers, right, rather than downside.
Okay, does anybody want to jump in on this one?
I think the only thing I would say is because I'm not from the academic world, you mentioned researching the right thing. I don't know how the right thing is defined. And I don't know if for some researchers there would be crossover between what they think is the right thing and what they think might be helpful to practitioners. I don't think anyone is suggesting abandon your research interests to only do what you think might be helpful to some practitioners. I think we're saying if there's a meeting of the minds, if there's collaboration that can happen, it should happen. Not that we're trying to shift, I wouldn't have gone to the critical legal conference in Durham and said, hey, everyone, why don't we get down into the nuts and bolts of the refugee, definition. I think there's different spheres of research interest. And if there is a meeting of the minds, let's let those minds meet, I think is what we were saying on the panel today. But happy to hear the thoughts of others too.
Well, so it may be that practitioners actually don't need help. That is, that the questions have been answered, or answered enough. I said 95% of the time the question is someone a refugee, or does someone meet some other protected definition? There's a lot of jurisprudence on that, with limited exceptions. You can say both that in this country there's quite a good jurisprudence on a lot of stuff. Our jurisprudence on gender-based persecution, our non-state agent jurisprudence. We've taken occasional wrong turns, like the House of Lords decision in Avan, and we came close to it with the House of Lords decision in Avan, which had to be dragged back by the Court of Appeal. But broadly, we have a lot of separate jurisprudence where we didn't 20 years ago. So maybe it's not practitioners, but as it were, the people dealing with policy, who are, as it were, more the people who need interaction.
I agree, and that's why I focused on policy as well when I was speaking. I also think it's something to which some practitioners, again, may have turned their mind, for example, in the passage of the legal migration bill, to think about how it might be litigated, but the vast majority, because it was not law, had very little interest in the nuts and bolts of what the bill said, whereas academics and others had some interest, and of course it was helpful to us trying to do policy influencing work to have relevant examples, including, as I said, of other jurisdictions that we can use in order to suggest why a different approach could be taken.
But on that as well, I mean, there are things that you can kind of see coming. And obviously when a bill is passing, that's a concentrated moment when you can see things that might come. And I suppose, but I'm talking about things like, the possibility that the Human Rights Act might be repealed. And then one of the things that I've written about myself is, well, what else would there be? Can you go back to the law of common humanity? You know, which is a concept introduced, what was it, 1830 something, which was discussed in Venezuela. But I mean, it's worth, you know, I think, you see, Eric, you're still talking about the Refugee Convention, but I think it's worth looking in that very, very seriously academic way at other areas of law that affect immigration control. What would we do without the Human Rights Act and the Human Rights Convention? You know, has the common law anything to say? I mean, I'd be very interested to read an academic discussion of that, for instance. And something else that I've looked at myself is, which I think is going to become more important, is the role of outsourcing, you know, which distances the migrant from their remedy, you know, because they can't sit. And I was listening to Ellen, what you were saying about the Frontex litigation. That's really, really interesting, because you have whole situations where you have migrants put in places or controlled by entities which are not the government. And who do they sue? Who do they get any satisfaction from? There's not enough research, to me, there's not enough academic thinking going into those sort of, and maybe people think those questions are kind of too practical to have academic research done about them. But I think we're going to be facing those kind of things, and nobody's talking about them except about 2.5 people. That's what I think.
Yeah, I do think there's plenty of scope for academic research to actually have a lot of use and impact. Elspeth has her hand up, so Elspeth, do you want to say something? My laptop has given up the ghost. So.
Yes, thank you. I have a few comments, and the first one is about expert evidence. And I think we need to be quite careful when we talk about expert evidence, because it's not necessarily expert legal evidence. It's often anthropologists and you know, various people who are sociologists who are doing field work who are giving the expert evidence. And we have an incredibly difficult time, even with things like medical reports, working interdisciplinarily, where what the lawyer wants is one thing, but the doctor thinks is relevant, and she can say is another thing. What the anthropologist thinks is relevant is a third thing. And to try and get other disciplines to focus down and tell the lawyer what the lawyer wants to hear is, I mean, maybe it's a good idea for a PhD subject, but it's incredibly complicated. The other, to Tamara, I would say on the downsides, one of the difficulties about immigration and asylum law in the UK in particular is that it changes every time the Home Secretary sneezes. So you have rule changes, and you have things where you wake up one morning and you discover there's something new on the website, and then it's gone 3 weeks later. It's incredibly fluid. And for an academic, that's impossible for us to investigate, because unless we're just investigating fluidity, the lack of the arbitrariness in the making and the unmaking of law, to actually look at these different bits that appear and disappear is would be cataclysmic to ever getting published, because you spend 6 months studying up on a particular bit that's appeared on the website, and by the time it gets for peer review, it's disappeared and it doesn't exist anymore. So I think that is really a problem. I mean, it's a problem which is much more profound, which is, what is the quality of law? Does this stuff actually qualify as law? And I think that question, as a bigger question about what has happened to immigration policy and law, and we have all the Pankina and all that kind of line of cases, but the question of the lack of any foreseeability whatsoever, I think, is a matter of perhaps would be of interest to quite a few lawyers, and might be interesting in a number of cases, but it would be much more transversal. So I think that we need to accept that academics are going to be interested in slightly larger problems and interests someone was saying, well, I think it was Shauna who was saying that there's a question about democracy. How has immigration law and practice come to debase the fundamental principles of democracy? And I think that's something that could be looked at as well. Whether or not it would ever go before a court is a completely different matter, but it might well do in areas like when you make deadlines for appeals so short that nobody has any chance of ever making it. Have you then made a rule which fails the arbitrary and impossibility requirements? So I think it's a matter of thinking creatively between how to find the ways in which what the academics are doing can be useful to the practitioners, though they may not answer the question which the practitioner thought she was asking.
Thank you so much, Elspeth. I think that's a really, really nice way of putting it, possibly answering your question, sort of bridging that problem, right? I think that's amazing. Does anybody have any thoughts on the question on funding? So I honestly myself don't know much about funding on the practitioner side and could only say something about funding from the academic side. Does anybody have any thoughts on that?
I don't, but if anyone does have any, let us know, because maybe we could seek that funding. I think the only thing I would say is that is where impact, like you were saying, how you're expected to have impact with your research. I imagine any funder, like that, for example, Justice Together initiative, if I said to them, why don't we go and have researchers or academics and practitioners meet and we're going to do a bunch of roundtables, they would say, what's the impact? What impact is this going to have in terms of promoting justice, in terms of, improving the system for migrants and displaced people? And we would need to have an answer to that.
Yeah, exactly. So you think
I made an application with ILPA before COVID for ESRC funding to look at the impact of changes in law and the voices of migrants. And we got fairly far, but we didn't get funded. I mean, it would have been excellent. We would have had a lot of working group meetings around the country to try and hear from asylum seekers and migrants themselves. But we also I did another application with Roundtable with migrants' rights. We didn't get that either. But that was because the academics were just too expensive.
that is always a problem, isn't it? Yeah, I do think that academic funders are keen on this idea of impact and would probably also be keen that you can show that you're collaborating with a migrants' rights organization, for example. But if it comes to sort of bringing together funding from both sides, I think that would probably have to come from the individual organizations working together rather than from the person seeking the funding saying, hey, can we have both of your pots? That usually doesn't really work so well. But yeah, it's an interesting question and be worth exploring further, I think.
It does remind me actually when Elspeth mentioned the ESRC funding that I sit on Helena Ray's board for research. She has ESRC funding at the University of Exeter to look into the effect of Brexit on migrant families. And so she has also others sitting on that board, like the 3 million. So to interface lived experience, practitioners, and to then have a holistic view through mainly interview research and qualitative research about the impact of Brexit on families.
What's really interesting. A smaller, much smaller level of funding might be available from the Society of Legal Scholars, which I think funds little programs of little meetings, what say like this, for instance. And so that's another way, because really what we want is to engage people in discussions. And so I suppose one might suggest, let's get a group of academics and practitioners who are interested in such and such a legal problem from either an academic and a practitioner point of view. Can we have an exchange of ideas on that specific thing? So it could be an hour and a half meeting on Zoom. It doesn't have to be a great production, but it would get people together. And I think even hard strapped practitioners might spare, you know, an hour and a half or two. So,
Yeah, we're certainly going to try and facilitate more of these. So yeah, absolutely. There was a question from Richard to Mark and Eric. Would you want to respond?
Yes, expert evidence. So, expert evidence is received in various ways. And obviously, the higher courts don't normally conduct trials in the first place, so you wouldn't really expect the higher courts to be engaging with normal expert evidence. Though obviously, they might engage with academic opinion on an issue of the law. The tribunals do engage in trials, and they look at expert evidence quite a lot. And over the years, they have been rather savage in their treatment of some experts. I remember one age assessment expert, suffering real career damage for a little while after some unkind comments were made. One country expert actually pre-actioned the upper tribunal for defamation, and got them to change, actually got them to back down and take a paragraph out of the decision about 10 years ago. So it can be a controversial area, but the Supreme Court in KB Sri Lanka were very good on medical evidence, though, of course, because the upper tribunal had taken a rather unreceptive view about the extent to which doctors could legitimately opine on the credibility of an asylum seeker. And the Supreme Court made it very clear that actually doctors could contribute rather a lot to that kind of conclusion.
Yeah. But I'll just say, sorry, I can't see Richard Hopkins, of course, because I hope I'm looking at him indirectly. Well, you know, I addressed legal academic work because that was, as it were, my narrow thesis, and I wasn't going to stray from it. But the social scientists of various sorts, acting as country experts or experts on particular situations, have been vital in sorting out some cases I've dealt with over time relating to really significant issues, and so their role has been pivotal in that context. But some of the problems I've described as regards representation also rub off as regards experts. So generally, the people who choose the experts aren't really qualified to choose the experts, and generally too, there's not much analysis of the suitability or aptitude of an expert that goes in. It's simply that the last expert you use for a particular country, whose advice didn't come back to you marked in red from the tribunal, you use again, because it's efficient. It's the most efficient thing for a harassed caseworker to do, and you go on doing that. And in academia, among social scientists, there's some people who do it, there's some people who don't, there's some people who seem to make a vocation out of it. And there's a risk of an appearance being given sometimes that, as it were, expert reports are coming off the pad. That there's a lot of cutting and pasting, that there's a relatively small amount of individual material. Sometimes the reasons for an expert report are relatively defensive, i.e., the solicitor doesn't want to be criticized for not having had an expert report. Sometimes you use experts, as it were, because the expert has a certain amount of protection that's simply asking for an ordinarily intelligent deduction from the Amnesty International report. It doesn't have it. And so you're simply, as it were, asking someone to put themselves in between the tribunal and the Amnesty International report. So it could be better, but at its best, it's really very vital and very positive.
Great, thank you. I realize it's coming up to 7, but because we started a little bit late, I hope people don't mind massively if we run over, but we really have to take our final round of questions. And we're just going to start with one that was online, which I can't see because my laptop battery is dead, but Violetta is going to kindly read out for us, please.
Yeah, thank you, Maya. There are 2 suggestions and 2 questions. So one comes from Joyce de Koning. I've shared the relevant link. She proposes that in terms of accessibility to academic materials, their repository, the e-journal actually on migration, refugee and citizenship law on SSRN can be a very good resource. We could even think about generating a specific channel. Queen Mary has a specific line of working papers. So if Ilpa or another practitioner's body would like to team up to generate a specific line of working papers, for example, we could have such a product, but it already exists in terms of providing open access material of various kinds, and it's accessible free of charge on the internet. The other suggestion is actually just coming from myself. I mean, if people have issues in accessing specific experts and so on, I was wondering whether it would be within the realm of ILPA's possibilities. Again, academics can help to generate a roster or a directory of people with specific expertise, so that when needed, you could have access quite quickly to them for submissions in court or for expert opinions or for whatever might be necessary. There are two questions then from Rami Abdelhadi. He asks, well, he's been working with the commissioner, the special rapporteur on refugees in Africa, Maya Sahli, who is also a law professor in her country of origin. And he asks, to what extent do you think academics in the UK can better engage and litigate before the African human rights mechanisms, either the African Commission or the court, in cases that involve violations committed by African states, especially North African countries, with which European states collaborate? I mean, violations in which I would say Italy, Malta, Spain, Greece might be involved. This would not be to focus on the EU human rights regime or the Council of Europe human rights regime, but rather use the mechanisms on the other side of the Mediterranean. So that's one question. The second comes from Jeremy Houston, who is an asylum and refugee officer. And the questions he has too are about positionality. So in terms of the volume of the academic material and research that is being produced and the complexity that is emerging, it would be important, he proposes, that this material is written with an adjudicator audience in mind, also to facilitate the selection that needs to come when preparing submissions or decisions. Then he also thinks that one needs to take into account the non-Western perspective of the applicant and their circumstances when producing material that is usable by a practitioner's audience. And so I suppose these are questions more for the academics in the panel. But back to you, Maya. I know there is somebody else in the room that wanted to add another question. Maybe we can ask them to put the question and then have a final round with all the speakers in the panel.
Yeah, thanks, Violetta. So one more question from the room, bearing in mind that there are drinks afterwards. So anybody else who has questions can then ask their question. Yes, please.
My name is Nana. I'm doing my PhD at Queen Mary University of London. I'm focusing on search and rescue at sea. And my question really is about accountability mechanisms and how, or like to what extent, practitioners in the UK could engage with accountability mechanisms like universal jurisdiction, and how academics could actually engage with practitioners within that field with regard to perhaps, I guess, humanity committed against migrants and refugees, potential facilities in the field. Yeah, generally. So, thank you.
Lovely, thank you very much. Okay, so shall we start with the first question? And I'm just going to say anybody who wants to answer the question can volunteer. And was the question on using mitigation mechanisms on the African continent, possibly, rather than on the European continent. Does anybody have any thoughts on that?
The only thing I can think of is the quote from NDNT, and that they had discussed that in that decision in the European courts, and that they should have taken human rights concerns to the African courts before they went to the European courts in that regard, which hasn't been received very well, understandably, but unfortunately that's all I can, that question comes to mind.
I think it probably worked as best received by the NGO community. It isn't funded, is it? The difficulty of the private practitioners in taking it up.
Yeah, difficulty also, I think, for lots of NGOs who aren't incredibly well funded in this country.
And for sure, you would have to be an expert in, you know, the judicial system that you're approaching, right? And I suppose if you're an expert in UK law, maybe it's not necessarily your field, but certainly a very, very interesting idea. And I'm sure there must be people who are pursuing these avenues. I think it's just because we are sort of more, all of us UK and Europe focused, maybe we're not entirely familiar with this, which is a bit of an omission. So I would be very, very interested to engage with that type of work eventually. The question on positionality, does anybody have any thoughts on that?
Well, I think I could come in on that a bit, and on positionality. I think that we need to remember that we academics, when we're teaching our students in the classroom, we don't know where they'll end up. They might well end up in the Home Office. They might well end up in the judiciary. They might well end up, who knows where you're going to end up, in the Crown Prosecution Service, etc. So for us, positionality is, it's not about, you know, are we taking a specific kind of, our obligation is to the creation of knowledge and the dissemination of knowledge. We may have our particular views. We may have both views about how the law ought to develop. And I think Shona was particularly good on that, saying that, you know, that there was this, you know, the Supreme Court was wrong on retrospectivity. And, you know, this is something which needs to be discussed. But I think that we need to bear in mind that unlike practitioners, at least the practitioners we're looking at here, who are primarily lawyers in practice, either NGOs or law firms, and we're not actually talking to practitioners who are, for instance, in the Home Office or in the courts, but they also are practitioners. So, and they also maybe where our students will end up. I was going to say something about using the instruments in Africa and the African venues to seek results. And I think the first thing we have to remember is just how parochial law is. You know, law belongs to the little space in which the law is made. So the law is made in England and Wales, and it's different in Scotland. And one of the things which being part of the European Union did for lawyers in the UK was it raised the possibility of it being interesting to work with lawyers across borders. And you had a tentative but an increasing interaction between lawyers across different jurisdictional lines within the European Union. Things get very ropey when you look at the Council of Europe. If you're looking at the European Convention on Human Rights, how many people ever worked with a judge from Armenia or Azerbaijan, let alone anywhere else a little bit closer? And the idea of finding lawyers in foreign countries is, I think anybody who's worked in a law firm knows this, it's the subject of infinite emails. The emails go around saying, has anybody ever worked with a lawyer in X place? And were they any good? And do they speak English? You know, and you get these little plaintive cries out, and everybody says, oh my goodness gracious, you know, what have I got in my in the memory in my computer? But it's always terrifying for lawyers to try and do work with lawyers overseas. So that's our first problem. The second one is the organization of the law societies and the bar councils in quite a variety of African countries are quite different from what they are in England and Wales. And if you want to see one place where lawyers from various African countries do actually come across lawyers from Europe and North America, it's the International Bar Association. They're about to have their big immigration conference in Paris on next week. And there you actually do come across lawyers who do immigration law in African countries, not the poorer ones though. It'll be Nigeria, Kenya, and South Africa who will normally be represented, but also a bit of South America. But the IBA, while it attracts lawyers interested in test cases and opening new horizons, and at the conference in Paris, Helena Kennedy is going to be talking about the Rwanda litigation, for instance, and she, of course, has very strong views about it. But it's an expensive venue for lawyers to go to, and it's really more a venue where lawyers who are working in cross-border economic mobility go as a general rule. Sorry, I've taken up too much time.
No, thank you, Elspeth. I think that was really, really interesting. And you certainly had some really, really good points there, which none of us would think of. So thank you so much. And I didn't see your hand up because I can't see the screen anymore. We've got one final question on universal jurisdiction. Did anybody want to jump in on that one? Quite a complex question, I think.
I didn't know enough about it to meaningfully comment.
Same here, unfortunately. Sorry. No, not our topic, unfortunately. But I do think that there are probably more questions which we can discuss over drinks. So thank you all so much for coming. Everyone's in the room, everyone who is online. Thank you for joining us and for typing your questions. And thank you for asking them. And yeah, follow I think you can sign up for the Border Center newsletter to receive emails for future events, and we're certainly gonna aim to have more of these. So please respond to the activities of the center. Thank you so much.